Be ready. Start. Notwithstanding anything contained in any other law for the time being in force, when the tribunal has jurisdiction to entertain and decide appeals from and revise decisions and orders of any person, officer, or authority to any matter aforesaid, no other person, officer, or authority shall have jurisdiction to entertain and decide appeals from and revise decisions or orders of such person, officer, or authority in that matter. In exercising the jurisdiction conferred upon it by or under this Act, the tribunal shall have all the powers of a civil court for the purpose of taking evidence on oath, affirmation, or affidavit, of summoning and enforcing the attendance of witnesses, of compelling discovery and the production of documents and material objects, requisitioning any public record or any copy thereof from any court or office, issuing commissions for the examination of witnesses or documents, and for such other purposes as may be prescribed, and the tribunal shall be deemed to be a civil court for all the purposes of sections 195, 480, and 482 of the Code of Criminal Procedure 1898, and its proceedings shall be deemed to be judicial proceedings within the meaning of sections 193, 219, and 229 of the Indian Penal Code. Section 15 empowers the tribunal to entertain question of interpretation regarding laws of public importance, which can only be decided after hearing the state government on the matter. Section 16 provides that no appeal shall lie to the state government against the order passed by the tribunal. Section 17 of the Act confers upon the tribunal the power to review its own decision on grounds similar to the ones mentioned in Order 47, Rule 1 CPC. Such a review application may be filed before it within a period of 90 days from the date of the said decision of the tribunal. Although term court has not been defined under the Act, it is undisputable that courts belong to the judicial hierarchy and constitute the country's judiciary as distinct from the executive or legislative branches of the state. Judicial functions involve the decision of rights and liabilities of the parties. An inquiry and investigation into facts is a material part of judicial function. The legislature, in its wisdom, has created tribunals and transferred the work which was regularly done by the civil courts to them as it was found necessary to do so in order to provide efficacious remedy and also to reduce the burden on the civil courts, and further also to save the aggrieved person from bearing the burden of heavy court fees, etc. Thus, the system of tribunals was created as a machinery for the speedy disposal of claims arising under a particular statute act. Most of the tribunals have been given the power to lay down their own procedure. In some cases, the procedure may be adopted by the tribunal, and the same may require the approval of the competent authority government. However, in each case, the principles of natural justice are required to be observed. Such tribunals, therefore, basically perform quasi judicial functions. The system of tribunals is hence unlike that of the regularly constituted courts under the hierarchy of judicial system, which are not authorized to devise their own procedure for dealing with cases. Under certain statutes, tribunals have been authorized to exercise certain powers conferred under some provisions of the Code of Civil Procedure, hereinafter referred to as the CPC, or the Code of Criminal Procedure, hereinafter referred to as the CRPC, but not under the whole code, be it civil or criminal. However, in a regular court, the said codes in their entirety, civil as well as criminal, must be strictly adhered to. Therefore, from the above, it is evident that the terms court and tribunal are not interchangeable. A tribunal may not necessarily be a court, in spite of the fact that it may be presided over by a judicial officer, as other qualified persons may also possibly be appointed to perform such duty. One of the tests to determine whether a tribunal is a court or not is to check whether the High Court has revisional jurisdiction so far as the judgments and orders passed by the tribunals are concerned. Supervisory or revisional jurisdiction is considered to be a power vesting in any superior court or tribunal, enabling it to satisfy itself as regards the correctness of the orders of the inferior tribunal. This is the basic difference between appellate and supervisory jurisdiction. Appellate jurisdiction confers a right upon the aggrieved person to complain in the prescribed manner to a higher forum, whereas supervisory revisional power has a different object and purpose altogether, as it confers the right and responsibility upon the higher forum to keep the subordinate tribunals within the limits of the law. It is for this reason that revisional power can be exercised by the competent authority, court suo motu, in order to see that subordinate tribunals do not transgress the rules of law and are kept within the framework of powers conferred upon them. Such revisional powers have to be exercised sparingly only as a discretion in order to prevent gross injustice, and the same cannot be claimed as a matter of right by any party. Thank you.